Good afternoon and welcome everyone. I'm Stephanie Anderson. I'm the CPOC Probation Foster Care Specialist. Thank you so much for joining us today. We're really grateful to have the California Tribal Families Coalition join us to present on the Child Welfare Act, which is also known as ICWA. We have heard many questions about ICWA, and actually we're starting to get more. And so we thought it would be a great opportunity to have them present on ICWA 101. So with that being said, I will go ahead and introduce our presenters, which is Geneva Shaw. She's the Training and Curriculum Development Director. And then also we have Mica Llerandi, who is the Senior Attorney for Legal and Program Services over at the California Tribal Families Coalition. Go ahead and take it away, Geneva.
Thank you so much, Stephanie, and thank you all for having us here today. We are very appreciative and very honored to share with you a bit about the Indian Child Welfare Act, ICWA 101. So we will go ahead and get started. So before we tell you a little bit about ourselves as presenters, I want to take a moment and offer a land acknowledgement. I personally am tuning in today from the beautiful homelands of the Wiyot peoples, which is located along the very northern California coastline in Humboldt County, California, way up northwest. So thank you and acknowledging the Wiyot peoples for their sacrifices and these beautiful homelands that I get to reside on. Mica, where are you tuning in from?
Hi, everyone. My name is Mica Llerandi. I am tuning in from Kumeyaay territory in what is currently known as San Diego, California.
Thank you. And if any of our participants know whose traditional homelands you are residing on, please feel free to share that in the chat so we can be sure and offer an appropriate land acknowledgement from all of the places that we are tuning in today. So before we begin, let's give a little bit of kind of overview of who we are as your presenters. So again, Geneva Shaw here, and I am the Training and Curriculum Development Director for the California Tribal Families Coalition. I am also an enrolled member of the Hoopa Valley Tribe and a descent of Yurok, Karuk, and Apache peoples. I am also a social work faculty at Humboldt State University. I've been doing that for approximately 7 years, and I've had a great deal of background has been in tribal social services, direct practice, and administration. Mica, let's hear a little bit about you.
Thanks, Geneva. As previously stated, my name is Mica Llerandi. I am the Senior Attorney for Program and Legal Services at California Tribal Families Coalition. I'm also Diné, or a member of the Navajo Nation. Prior to joining CTFC, I worked in various legal capacities, first on my Navajo reservation as a domestic violence attorney. Then I moved over to some other Southern Arizona tribes where I worked in the probation or prosecution department, where I did a lot of interfacing with the probation departments there. And then I worked with Salt River Pima Maricopa Indian community as a guardian ad litem for tribal court cases dealing with dependency. And then I moved over to California. When I moved to California, I started as a minors counsel with California or Children's Legal Services of San Diego. And then I just recently left California Indian Legal Services, where I represented tribes in ICWA matters in California court.
Awesome. Thank you. And for those of you who are joining us, we would love to know a little bit about kind of where you're at, not only where you're tuning in from, but also kind of a little bit about your professional role, your title, and certainly if you have any direct interfacing with tribes, tribal issues in the Indian Child Welfare Act, please feel free and share a little bit about that also in the chat. And then Mica, if you want to go ahead and get us grounded today as we move forward, that would be great.
Sounds good. So we're going to be talking about some pretty heavy topics in the first hour, and then a little bit more about the Indian Child Welfare Act. And in order to kind of deal with all of the traumatic nature or the very difficult nature of the topic, I like to offer what we call, Navajos have a blessing way ceremony. And in our blessing way ceremony, we have a closing prayer, and it's called Walking in Beauty. And it's really just great because it helps you reframe your mind, reframe your focus, and just really get grounded in where you are. And so it begins. In beauty I walk, with beauty before me I walk, with beauty behind me I walk, with beauty above me I walk, with beauty around me I walk. It has become beauty again. Today I will walk out. Today everything negative will leave me. I will be as I was before. I will have a cool breeze over my body. I will have a light body. I will be happy forever. Nothing will hinder me. I will walk with beauty before me. I will walk with beauty behind me. I will walk with beauty below me. I walk with beauty above me. I walk with beauty around me. My words will be beautiful. In beauty all day long may I walk. Through the returning seasons may I walk. On the trail marked with pollen may I walk. With dew about my feet may I walk. With beauty before me may I walk. With beauty behind me may I walk. With beauty below me may I walk. With beauty above me may I walk. With beauty all around me may I walk. In old age, wandering on a trail of beauty, lively may I walk. In old age, wandering on a trail of beauty, living again, may I walk. May my words be beautiful.
Thank you for that, Mica. Very much appreciated. And if you would also share with our audience today a little bit about California Tribal Families Coalition, who we both have the honor and privilege of working for, and a little bit about the great work of CTFC, as we will refer to it by.
Of course. So California Tribal Families Coalition is a nonprofit organization. We are tribally led with a board of directors that are full tribal or just tribal leaders throughout California. And the mission of California Tribal Families Coalition is to promote and protect the health, safety, and welfare of tribal children and families, which are inherent tribal governmental functions and are at the core of tribal sovereignty and tribal governance. So CTFC was actually formed, and you'll see this little icon here with the California ICWA Compliance Task Force report. So back in about 2015, several tribal leaders in California got together and went to then Attorney General Kamala Harris and said, hey, there are some challenges and some issues with ICWA compliance throughout the state. We would like to address these issues. And then Attorney General Kamala Harris said, please prepare a report with recommendations and we will see about implementing them. So the tribes throughout California got together and prepared this report in 2017 and submitted it to then Attorney General Hector Becerra, who is now at HHS, and said, here are our recommendations and so forth. And one of the recommendations that came out of the task force was to have a entity designed to ensure that ICWA compliance was occurring both in the courts and legislatively and just all across the state of California. And that was California Tribal Families Coalition. So we are the successor organization to this ICWA compliance task force report. And we are really working to make sure that the recommendations put forth in the task force report are taken root and taken very seriously. So that is a little bit about us and a little bit of the work we do.
Awesome, thank you. So as such, there will definitely be some California emphasis on the information that we share today, while some of which is also very much applicable throughout the nation. So here we go. All right, so another kind of chat function ask now or anytime, feel free to share in the chat feature what you hope to get out of today. So if there is any burning question that you've been seeking, needing some answer to, needing some clarification on, whatever that may be, feel free to drop it in the chat, again, either now or anytime throughout the presentation. We will also have designated times for Q&A, so if things come up, but we will be doing our best to also monitor the chat and seeing if we can get your training needs met today. So a little bit about our intent and overview of the day. Always, strengthening county, state, and tribal collaborative relationships are at the heart of our training and presentations when it comes to the Indian Child Welfare Act and the compliance of. We're going to be seeking to tackle that by the 4 points on the right-hand side of your screen, ranging from recognizing the historical, philosophical, and legal basis of ICWA. We are going to work to see that we can recognize that ICWA is a remedial act intended to address the historical trauma experienced by American Indian and Native American peoples that results in distrust and challenges to engagement with Native families. We are going to hopefully understand the concept of tribal sovereignty and the value of collaboration with tribes. And finally, we will do an overview to identify the basic provisions of the Indian Child Welfare Act. I will say this is a lot to cover in the time that we have to do so. So we are going to do our best to cram a lot of information in. But again, we will take some thoughtful pauses to address questions and answers, and then some of which, we may have to kind of jump through a bit for the sake of time, but just know the information is there in your handouts in the PowerPoint, and you are welcome to follow up with us too. So before we begin with ICWA specifically and the provisions, I think it's really important that we have an understanding of where we've been so we know kind of where we're at and where we're going. And to really understand the who, the what, and the why of the Indian Child Welfare Act, we have to really kind of get into the historical context of what led up to its passage, how families and communities continue to be impacted by the impacts of history. So again, that, we can understand ICWA as a remedial act and not something intended to create more work for us, more paperwork, or whatever that may be. We have to really to be champions and advocates and allies for the act and its compliance. Again, we have to have kind of this historical context and backdrop. So I thank Mica for sharing those words, those prayers with us to kind of ground us, because indeed, much of our history of colonization and of the colonization of peoples is really emotional and is really kind of traumatic. Even kind of going into the presentation, as many times as I kind of teach or train on our history, it always creates some type of trauma response in me, because it's very personal, it's very real, and it very much impacts our peoples and our communities today. One of the kind of foundational themes or concepts or theories, if you will, that we will cover to understand how people are, thriving and surviving today is to also understand historical trauma. So before you have a definition of historical trauma, but essentially the creation of kind of the theory or understanding of historical trauma is the idea that traumatic events experienced by groups of peoples are passed down, from generation to generation. Research has proven that, traumatic events experienced by communities over and across generations actually changes our DNA, and our DNA is altered in a way that, each successive generation after us, absorbs and takes on some of the trauma that, our previous generations have experienced. So again, you can see this definition before you, and historical trauma defined. And we'll talk about this a bit more and kind of unpack this a bit more as well. Also, we see before us this graphic of the phases of the trauma transmission. So again, the ways in which the traumatic experiences that are experienced by our generations before us, how those are passed down, and how those, are experienced by communities, by individuals in a contemporary context. So the experience of, our ancestors of American Indian peoples, tribal peoples, Native American peoples, in their experience with our experience with colonization has had real and devastating effects, in that, our peoples were never able or given space or acknowledgement to really heal and recover from the perpetuation of massive group traumas. As such, when you experience really intensive group traumas, and we'll talk about, those a bit more, But those, you have trauma responses, right? And when you're not given space and opportunity to heal, your trauma responses and your coping mechanisms are passed down from generation to generation through environmental and psychological factors. So the American Indian Holocaust, we're going to go through a little bit of historical events. Some scholars, some tribal leaders, some tribal historians, and just tribal peoples also may refer to this as an apocalypse. Our peoples experience an apocalypse in which our societies that had been thriving and functioning since the beginning of time were dramatically impacted with the quote unquote discovery of America. It's oftentimes creates some feelings, some conflicts, some questions in folks, because we don't necessarily learn about the American Indian Holocaust in our public education systems. We don't even necessarily learn about these historical events with accuracy in our experiences with higher education. And so when we are kind of moving through these historical events, sometimes that can create some emotions of anger, shame, defensiveness, any number of different things, certainly sadness, but really important to acknowledge, the truths of what happened to the peoples that resided on these beautiful lands from time immemorial. And that was, in fact, an American Holocaust that started with invasion and continued on for the subsequent, several hundred years. This was a time period when, peoples who were quote unquote being discovered and first being impacted by settlement and colonization experienced a great deal of death by disease, famine, and out murders, or even, large group killings, for lack of a better word. This was also a time period when sovereigns of, outside of the Americas were making treaties with the tribal peoples for the exchange of lands with promises of, various protections and things of that nature. This was also a time period when, as this country was forming and our government was forming, that the Department of War was brought in and given the task of dealing with the Indian problem. And unfortunately, the tactics and strategies and policies to deal with the Indian problem were very much rooted in, removal and relocation, and some other really horrific ways to deal with human beings. We get into the California mission system. So looking at California specifically, by the time westward expansion hit California, the tactics to deal with the quote unquote Indian problem hit really fast and really hard. And this was a time period when gold was also being discovered. Before that, the mission system was being established in the state of California, and our peoples were really decimated. It's estimated that in a time period of, this kind of 1769 to 1830s, that approximately, 85 to 90% of the California Indian population was annihilated. So I'm going to pull up this video so that we can share and see a little bit about California's history specifically. I'm going to go ahead and stop share, and then I'll reshare to the video. So bear with me really quickly. And then I will reshare to the video.
For California Indian history specifically, I think it's important for people to know that California has always been a populous place. It's home right now to 109 to 111 tribes, but back then you're talking about tribes everywhere. There is no empty space of wilderness that exists in this place that we currently call California. The way you know that there were California Indians everywhere is that every place had a name. There was not a mountain or a field or a region that there wasn't a tribe who had already named it. For the sciences, I think that the land bridge theory has always been sort of a first point of knowledge about Native people. But there have been new studies that have shown that there was humans in this side of the Americas over 100,000 years ago, which would mean that that is around the same amount of time in which they say people were sort of first leaving Africa. And so we are asking people to complicate how they understand who we are as Indigenous peoples here. What we say is we're from this place.
And that's a real and true belief that we have. We are a part of the land, and the land is us, and we didn't migrate from some other place. We've always been there.
We've always been a part of our land, and not above it, not below it, but equal to, and we have our role. Our roles come from that engagement and come from seeing what needs to be done to make things the best way that they can be.
So all of this is very important for people to understand, because I think sometimes they think Californian people are here, but they're not really doing much with the space. There's so much evidence of like agriculture. There's evidence of large areas in which they're tending to. There's evidence of ways in which they're shaping what we now think of the natural landscape. And then colonization happens. Most California scholars, they call it invasion. So we're being invaded.
When Cabrillo was first on one of his ships in 1500s, burning of the land is what actually gave away people on that land. That was like the first thing that, colonizers saw, was our traditional burnings of the lands.
You're talking about 3 waves of destruction. From the start of these waves, there's not really a time period in which California Indians can recover from what's happening to them. So the first wave of destruction is the Spanish mission system. They build the first mission in San Diego. There's 21 missions that they build in total. This is Father Junipero Serra. And they're bringing people into the missions in the hopes that they can create this labor force to be able to establish this extension of Spain. The mission system is effectively an enslavement system of California Indian people. The missionaries bring along with them Spanish soldiers. The soldiers are written about in these records as being perpetrators of sexual violence, not only against women, but also children. Junipero Serra actually talks about that in his journals. He's like, they are sexually assaulting women and children in front of people. And when people try to stop them, they get shot. I mean, it's a very violent type of situation. The mission system sort of stops around San Francisco. And so up here in Northern California, what they say about us is we were contacted relatively late in the sort of colonization cycle. We had contact with some explorers who had come through, people that were looking mostly for gold. And at a point, they find gold. And this is where you get these sort of like massive influx of the gold rush.
And it just came like overnight, and it came in hard. And life just changed drastically and just immediately in a lot of ways for California people.
They're not here so that they can set up a colony or so that they can establish a labor force. They want gold. They will kill whoever is in the way. They will take apart whatever needs to be taken apart. They'll do whatever it takes. The thing about the gold rush that people don't think about is that it was actually an environmental destruction as well. And then on top of that, they are setting up a political system and a state system of laws and governance that will legalize the genocide that they want to commit against California Indian people.
Our first Lieutenant Governor, Peter Burnett, saw this huge population of Indians in the state. And so he's the one that, charged the war of extermination on the California Indians. And we lost, probably around 80% of our total population in just a short period of years.
The early settlers wanted the resources. They wanted what would make them rich faster. But instead of asking the tribe to help them or assist them, they said, well, since the tribe probably won't just give to us, we're just going to wipe them out, we're going to massacre them, we're going to take everything for ourselves.
Each region of California is allowed to set their own sort of what are we going to pay for a scalp or a head. But when you look at advertisements, what you see is that they're advertising them at things like $5 a head and 25 cents per scalp. The first year that they do this, they pay $1 million. The state of California says that it has paid $1 million for killing Indian people. The second year they do it, it's $1 million. In this region, every single tribe in this region would have some kind of stories about the violence that came out of the gold rush. My great-grandfather, his family is from Kadu country. His great-uncle his mom had lived through the gold rush, and he was born sort of like at the tail end of this period of time. And he would always say to my mother, remember, granddaughter, you're here because some miner was a bad shot. Like, that's how close it is to who we are.
When modern contact, we had to forget about all our relations. We had to forget about all the sciences, and we had to forget about all the philosophies. We had to forget about everything that was ingrained from us for thousands of years to a shattered existence.
They would take your kids from your family and take them to boarding schools and assimilate you. You were not to practice your cultures. You're not to practice your traditions. You're supposed to practice, I hate to say it this way, the white man's religion. We're going to Christianize you. You're going to follow our God.
I know that I'm a product of forced assimilation. I know I was stripped of some of the smartest information a human being could have. And I know I don't have that now. But I know it's attainable over time. And we're on the right path.
There's all these great moments of Native people making sure that they were trying to hold on to things, like fighting back and making plans for the future. It's palpable in Humboldt County.
The Native American community, and especially the Weats and the surrounding tribes, were put through a lot. It wasn't just the Weats, it was Yurok, Hoopa, we were all put through a lot during the early years. Here we are, we're growing. We're becoming a stronger nations. We're working together with each other to create a positive thing. And not only with us working with each other's sister tribes, we're working with the cities, the governments that surround us, the schools, HSU, to make this more positive.
Humboldt State University is within the Aboriginal territory of the Wiyot people. And then we have several other large tribes around here, the three largest in California, the Karuk, the Yurok, and the Hoopa. So being that we are in the backyard of three of the largest tribes, we can draw off and partner with some of our local tribes to bring that extra educational component to our STEM and natural resource students. Here, the Indian Natural Resource Science and Engineering program and Diversity in STEM We go by Intercept Plus. Our services generally provide navigational suggestions to students, assisting them navigate the College of Natural Resources and Sciences. We often are enriching that experience with extracurricular activities coming from an Indigenous perspective. So bringing up our ancestors' practices and techniques of managing landscapes, melding them or braiding them in with the scientific method and innovative technologies.
In Native Studies, we're doing a sort of broad spectrum of what it's like to learn from Indigenous peoples and cultures and knowledges so that we can build a better world, build a better way of knowing. It's about how we learn with and from Native people instead of disciplines historically that have focused on the study of Native American people. My paternal grandmother was one of the founders of the Indian Tribal Education Personnel Program, ITEP, back in the late 60s and early 70s. Her and a bunch of other mothers and grandmothers, they were the ones that kind of started a lot of our other community programs, our healthcare programs, our education programs. I always think it's a pretty amazing story because a lot of those women, her included, had attended boarding schools. And for those women to come back from that and still understand that we needed health and we needed education and we needed a strong community.
When you talk about the Indian Tribal Educational Personnel Program and United Indian Health Services having these women with moxie, they come from a generation of women who have been having to just hold that strength for such a long time. And part of the work as tribal people is how do we go back and tap into that? Because that's always there. We come from a long line of those folks who are moving forward and have had to keep their dignity, keep their pride. And although it hurts, we're still doing that work. That's what I try to tap in for the young people, tribal people in particular, but also for non-Indian students to hear that too, that it's not all historical trauma and then we're gone. No, it's historical trauma. We're still here and we're not going anywhere. We're still learning, we're still enduring.
One of the reasons I really appreciate that video is because not only does it give you kind of a glimpse into the history of California as experienced by the original inhabitants of California, but it also really highlights Indigenous brilliance and success. And I think that's really critical that we not only focus our energies on knowing and understanding Indigenous trauma and suffering, but we also take the time to celebrate Indigenous success and brilliance, like I said. And I really encourage all of us in our work, not only with tribal peoples and communities, but all peoples and communities, because we work in fields that are oftentimes really focused on the challenges, the struggles, the what's not working well, and really like sitting with people in their times of trauma, in their times of struggle. And we also have a professional responsibility to show up and engage with communities during those times of also celebration and wellness and participating and being a presence in those spaces as well. So I'm going to go ahead and share the PowerPoint and we will pick up where we left off. All right.
And I'm actually going to drop a book titled An American Genocide by Benjamin Madley, which came out just a couple of years ago. It does a really good job for folks who are interested in learning more about kind of what happened in California, because it's so hard to find all of that documentation. So if you are interested, it's a pretty lengthy book. It is very texty, so be prepared.
Yeah, good one. Thank you, Mica. All right, so kind of moving on in the sequence of kind of historical events and context leading up to the passage of the Indian Child Welfare Act. And again, really important to understand the intensive kind of trauma, the intensive experience with settlement and how like populations were devastated, how, life was disrupted so that we can, further understand why the Indian Child Welfare Act is so important and why our efforts to engage with the compliance of the act is so critical and important. So we kind of, moved through contact and beyond. I'm not going to go through this too much because we kind of touched on it, but the 1800s, really a time of removal, American Indian peoples being intentionally removed from their homelands, oftentimes, very far away from their homelands, which as Indian peoples, we're so connected to our place where we're from. That's so integral to who we are, a part of our spirituality and cosmology, a part of our, not only our identity, but how we survive is in relationship with the land, our relationship with the land in the way of not only harvesting, our traditional foods, but also in the way we engage in stewardship with place and with lands. Such an integral part of what sustained us for such a long period of time. So removing peoples from their lands, from their homelands, again, kind of an intentional tactic to break up tribal lifeways, and shift people into the intent of assimilating into mainstream modern day American society. And that was done through a variety of federal Indian policy, also some great materials out there on kind of the history of federal Indian policy, where you can see, the impacts over time of dealing with the quote unquote Indian problem. And one of the challenges with the history of federal Indian policy is it lacks consistency. So we have kind of the early years of like annihilation, if you will, being the focus. Then we get into this time period of removal and again breaking up of Indian lifeways, of tribal community in the way it existed, and also doing so in ways that created opportunity for the taking over of lands, for colonization and further settlement. So this is the time period when reservations started coming into formation and people's being relocated onto reservations, which in many ways were not necessarily highly desired, highly fertile lands. Some of these, this time period, reservation life really had semblance of like, concentration camp or enslavement camps, where peoples were made to be dependent on, the federal government by way of governmental food rations, and other, basic necessities. So populations were already decimated, peoples were disconnected from their lands, people were forced into dependency on the federal government. And as you can imagine, this was an extremely kind of vulnerable peoples. I'm not going to go through this because the film really covered it, but again, just kind of highlighting the waves of destruction, the waves of devastation, and kind of emphasizing the point prior that we have generations of people that have experienced such extreme trauma and devastation and impacts, and just the frequency of death, a lot of violence, with no real break, no real break in that devastation to heal, to recover. But this is where kind of this, generational passing down of the historical trauma is really, you can see and experience, how that may be when it was such a continuous wave of devastation.
And I just wanted to throw in like a quick anecdote. So a lot of people, for context, understand like how difficult it was during the Holocaust. There's studies that say that during the Holocaust, Jewish people who were in the concentration camps were given about 700 calories a day, and they were subject to all of these very grueling work times and work periods. And if you actually go to the San Diego mission here, there was some nice, or not nice, there were some very informative like tables or like plaques that were set up. And they said that when looking through the priests' records of like what the Indians who were enslaved were fed, they were getting 400 to 600 calories a day and expected to help build these mission societies. So really just going to the idea that natives were very much enslaved. Like, we don't like to use the term slavery. People are very uncomfortable with it, but it is the reality. It's what Native Americans and Native Californians experienced during those first times and those first interaction with Western society.
Yeah, thank you for adding that, Mica. And I think, our use of language is really significant. So for example, when you read history books, when you, look at like public education curriculum, they will cite things like, how many Native peoples died from disease, for example. And really, again, we need to like further complicate that and understand how impactful our use of language can be. Because when you think about those types of circumstances, living in, concentration camp type, settings, living off of like 500 to 700 calorie, unbalanced diets, being made to work like endless hours, day in and day out, grieving like intensive community and familial loss. And then you get some type of like flu or sickness. It can be easy to be like, yeah, these people's died from disease or died from the flu, but you have to really like further complicate and understand that that's not entirely accurate. There wasn't like, take a sick day, go and rest, make sure you have plenty of fluids. It was like these really grueling enslavement type conditions. And then unfortunately, the nicety of like died by disease or died, from the flu is actually really not a very accurate depiction. And I think it's really important that, we understand truth, that we kind of, further like educate ourselves on truth, and that we can, ultimately be advocates for truth as well. So this was also touched on in the film. Also, a lot of really, impactful and well done materials. If you want to further kind of just explore these conversations and areas, but the boarding school in particular, allotment and boarding school, kind of the next, wave of intentional destruction of American Indian peoples. So ultimately, like we kind of, move through like the backdrop of what happened. And then kind of once we get into the latter part of the 1800s and into the 20th century, the intention or energies were shifted to really target the children. And so children were removed from their communities, removed from their families, removed from their reservations, and sent away to boarding schools. And these are children as young as 3 and 4 and 5 years old. They were intentionally moved a great distance so that there would be no contact with family. And the intention of these boarding schools were to kill the Indian and save the man, which was kind of the infamous quote of the system, and how it was designed and intended to exist. And I want to also point out that, the boarding schools were considered to be very progressive of their time in this, method and mechanism for assimilating Native peoples into mainstream culture, specifically targeting the children to, Christianize them, to, teach them kind of mainstream American, family structures and, skills. And this very progressive at the time kind of method for dealing with the quote unquote Indian problem. A lot of children experience, extreme, violence and abuse, and even many deaths occurred at the boarding schools because of, death by disease and some of these other mislanguaged, impacts. But it was also many individuals who were working these systems and who were a part of them, I believe, also did so with good intention, who thought they were helping and thought they were doing something to help these poor Indian children. And I say that because, in the line of work, I'm a social worker. I know some of you are, if you identify as a probation officer, or whatever your professional identification is, I think oftentimes we can agree that we do this work because we have intentions to help, right? We want to help children, we want to help families, we want to help communities. And so we have to really kind of be aware of the history and legacy of helping when it comes to some, groups of peoples who have been historically underserved, oppressed, and harmed by the systems that we represent. So I say this specifically because as representatives of governmental agencies, of, justice systems, oftentimes that can come with some negative connotation for communities who have legacies of kind of misinterpreted help and intentions that were good, yet created some really impactful and long-lasting harms. Here's just a quick visual of land loss experienced over time. You can see the colorations showing American Indian land loss from 1784 to the present. And finally, the green on the final moments were the reservations and tribally controlled lands that exist today. So very quick, very swift, very real loss of lands. Really quickly, I'm just checking time. So then we get into the 1945 to 1960s era, where, there's another wave of, kind of undoing or doing away with the Indian problem. So there was a period of time between the 1930s to about the 1950s when there was a shift back to, well, let's try and kind of put some tribal control back into tribal hands. There were some policies that were intended to support tribal sovereignty. And after it was kind of found that the conditions of the boarding schools were really, really, really devastatingly impacting tribal peoples, lifeways on reservations were, extreme poverty, extreme living conditions. So there were some efforts to, again, strengthen tribal sovereignty and self-determination. That was very short-lived before the pendulum swung back to doing away with Indian peoples and for the government to get out of the Indian business. So that was done during this time period where tribes, federally recognized tribes were terminated, meaning they lost their federal recognition. They lost their, federal protections that were established during treaty making processes. This was a time period when especially naturally resource rich tribes were first scheduled for that termination so that their natural resources could be harvested and taken over. This was also a time period where individuals, tribal peoples were given, you can see this flyer off to the right, they were given promises of a new and better life in urban areas and urban centers, one-way tickets with promises of good jobs, happy homes, training. In places like beautiful Colorado, we can see other urban hubs, ranging from the Bay Area, Los Angeles, New York, and many others throughout the country. People sent away to these urban hubs for a new and better life, oftentimes with many broken promises once they got there. And this was again another attempt to kind of dismantle, tribal community and society and reservation community and life. And then of significance too, to the leading up to the passage of the Indian Child Welfare Act was this policy called the Indian Adoption Program, where the government partnered with Child Welfare League of America and private adoption agencies, as well as private religious groups, to intentionally remove and adopt out Indian children. And this was before the time period. There was no reunification efforts. There was no opportunity for families nor their tribes to be able to have a understanding of what was happening, nor any opportunity to have their children brought back to them. But this was a funded effort to adopt out Indian children into white homes with the idea that they would have a better life than being raised as these poor Indians. So a time period when many, many, many children were lost to adoption, and again led up to the passage of the Indian Child Welfare Act, which we will get into. I'm not going to get into relocation and termination too much more, but just know these slides are here. Super encourage, if you're interested, additional research and follow up. We just don't have time to fully cover that today. But I do want to share another just quick visual. I think it's also impactful to kind of just bring home this idea or just kind of our understanding or knowledge or even emotional connection to historical and intergenerational trauma. So I'm going to do a quick stop share and do another reshare. Bear with me. All right, here we go. And then from
The story of our communities, people and nation starts a long, long time ago. More than 60,000 years, in fact. This was when our culture and our law first started to thrive. We knew who we were and where we belonged. We took care of each other, our land and our waters. We ate food that made us healthy, lived on country and abided by our laws and song lines. Our families, our children were happy, with strong minds and hearts, because they were where they belonged. But then, everything changed.
Colonization came, bringing wars, disease, famine, violence, and the destruction and violation of our cultural laws, sacred sites, families, and communities.
We were denied our knowledge, language, ceremonies, and identity. The very things that tell us who we are and where we belong. And our connections with each other and the land grew weak.
And then, our children were taken from us. They had their names changed and their identities stripped away. They were told that Aboriginal people were bad. Worse still, they were told that their parents and grandparents did not want them.
For years this happened, and those children became known as the stolen generations.
Our children were denied love and experienced physical, emotional, and sexual abuse. This left very deep, very complex, and very real wounds, leaving scars that are still being felt personally, socially, spiritually, and collectively.
In the time when our story started, we were able to parent in the cultural way that has seen our families survive and thrive for generations. Our people were strong, and our culture flowed and healed us in times of hurt.
But since the trauma of colonization and the stolen generations, we have not been able to heal in the same way. And we have unknowingly passed this trauma on to our children through sharing our sad stories and having them witness and experience our pain. This is known as intergenerational trauma, and we see symptoms today in broken relationships, disconnected families, violence, suicide, and drug and alcohol abuse.
But this is not where our story ends. We still have strong minds and hearts, and we still know who we were and where we belong. By creating safe and strong communities together, supporting our families to be free from pain, returning to our culture and building a strength of identity, we can stop the cycle of trauma and bring about positive intergenerational change so that we can continue to thrive for the next 60,000 years.
So while that film was focused on the Aboriginal people's experience of Australia, this is very much the similar experience and translatable to that of the American Indian peoples here in the United States and up into Canada as well with the First Nations peoples. I'm going to jump back over to the presentation. I'm not going to go through the rest of these trauma slides in detail for the sake of time, but just know that they're there. You can see here some of the negative trauma effects and how that shows up at the individual, the community, and the family level. So that is in your handout, and how the response cycle, historical trauma response cycle, kind of is perpetuated and continues in the passing along to subsequent generations and the unhealthy coping mechanisms. And then that brings us to kind of some of the contemporary realities of how that shows up in our work and things that we need to continue to be aware of, whether it be, any of these 4 points listed before you or others. but the reality that American Indian women are at least 2.5, if not more times more likely to be raped in their lifetime. 1/4 of American Indian children today still living in poverty. Native American youth ages 15 to 24 being twice as likely than the national average to experience death by suicide, and Native American children having the highest rates of accidental deaths due to car, firearm, and pedestrian-related accidents. So we continue to have a lot of work to do in the way of healing, and that's where some of you and our collective work comes in. Are there any questions before we move into the next segment of the presentation? All right, I know it's a lot, and that was just like very tip of the iceberg and very rapid, but at the same time, still kind of really, hits you in a variety of different ways. So we thank you for moving through that with us. And again, encourage you to continue just getting even more familiar with not only the realities of history and the places that we love and call home, but how that continues to impact communities in a very real and very contemporary context.
All right, so I'm going to take over from here, Geneva. Thank you for providing that very important historical context and really just for understanding how ICWA fits into where ICWA fits in, especially given the history. As the previous two slides kind of highlighted, there's a lot that's still kind of current for the need for ICWA. Sometimes people and sometimes folks, say, is ICWA still relevant? Is it still important? And the contemporary realities that we just showed were kind of there to highlight that, yes, Native communities are still struggling with all of these different impacts, and they are related to the historical trauma and the generations of trauma that's been inflicted upon our Native communities. So Geneva did kind of shared a lot about the federal Indian policy that has been this pendulum swing that is essentially taking so many different twists and turns and basically used a lot of the Native Americans as kind of guinea pigs. They didn't know how to implement different programs. They didn't know how to deal with the quote unquote Indian problem. And as a result, there were many disastrous effects, including breakups of Indian families, breakups of Indian communities, loss of land, loss of culture, loss of identity, and that all comes into play with the historical trauma aspect of it and kind of where we are today. A lot of Native Americans really rely on their culture, and there's this idea of culture match, like if you are able to connect people's culture to who they are, they're able to grow, they're able to thrive, they're able to survive. And just like within any context or any community, if you know your roots, you're able to grow strong. If you know where you come from, it is very helpful. And for the same thing with Native Americans, a lot of them, because of these prior past traumas, because of these prior federal Indian policies, don't really know a lot of their history. And so that's kind of where we all come in this work. It's how do we reconnect Native American communities to their cultures, to their tribal communities, to really start growing and start having that root. So nationally, when the Indian Child Welfare Act was being contemplated, the Indian Child Welfare Act was passed in 1978. And prior to its passage, there was a requirement that, so just to give a brief background of federal Indian law and kind of the federal government's responsibility for working with Native American tribes, is there's this thing called a trust responsibility. So this came about from three court cases, Supreme Court cases back in the early 1800s, and they dealt with the Cherokee tribes. And some of the key terms that came out of it is that tribes are what are called dependent domestic relationship or nations, meaning they're independent nations. They are currently in here, but they are domestic in that they are within the boundaries, the exterior boundaries of the United States. but they're also dependent. They rely on the federal government. And then there was this other idea of a federal trust responsibility, meaning that the federal government saw themselves as a guardian to tribes, meaning tribes were deemed wards. So if you're familiar with guardianships generally, you know that the guardian is there to protect, to look out for the best interests of these people or of their ward. And that's kind of the idea with the federal government and tribes. So the guardians, the federal government has a duty and has a responsibility to make sure that tribal communities are connected. So that's where these policies come in. And that's why it's really important to understand where we got ICWA from. There was a report in the 1970s that the Bureau of Indian Affairs, they are an entity in the federal government under the Secretary of Interior or the Interior Department that is charged with handling all affairs that are related to Native Americans. Prior to that, prior to getting subsumed by the Department of Interior, they were in the War Department. As Geneva shared, the War Department was really focused on addressing the Indian problem. But then once a lot of the disastrous effects occurred and tribes were weakened, tribes were no longer seen as like a threat or a hostile threat. And so they were pulled into the Department of Interior, where, you know, you have the land management, the national parks, and so forth. So the Bureau of Indian Affairs is housed in there, and they have to write a report. And in the 1970s, they prepared a report on just kind of Indian affairs generally. And one of the topics that came out was this high rates of removal of Native American children. And there was also a really strong, powerful movement going on in the 1970s for Native Americans. If you want to look into more about it, like started in the 1960s with the American Indian movement, there were a lot of strong Native American people who came out and said, we are seeing all of these problems. Like, federal government, you have a responsibility to take care of these issues. And one of the big issues that came out was the loss of Native American children. Kind of related to that, it was also a time in federal Indian policy where we were moving towards what's called self-determination. And that's currently still like the area of federal Indian law that we're in, making sure that tribes are able to self-govern and be in control over their own tribal communities. So a lot of background to kind of get us to where we need to be. And that gives us the statistic of 25 to 35% of Native American children being removed from their families and communities. And again, this is only the documented cases. When looking further into this issue more closely, it doesn't account for cases where children were voluntarily placed with other people. It doesn't involve cases like back in the 1940s to the 1970s, there was like a program called the Mormon Placement Program, where Native American children were voluntarily given to the Mormon church so that they could grow up in nice Mormon families and they wouldn't have to go to the boarding schools that the Bureau of Indian Affairs put together. And so that's another data point that we don't fully have information on. It doesn't involve children who were removed for criminal matters, such as juvenile delinquency issues, and they weren't captured in this data of children being removed from their families and communities. So we still have a pretty high number, though, that is generally equated to about a quarter to a third of Native American children no longer being in their families. In California, prior to the passage of ICWA, over 90% of the children who were removed were placed in non-Native homes, and Native American children were 8 times more likely to end up in adoptive placement. So next slide. So the big part of ICWA is that it was meant to be remedial. Its focus was to make sure that this alarmingly high percentage of Native American families broken up by unwanted removal or unwarranted removal needed to be addressed. And how do you do that? And one of the big reasons that Congress had to intervene, again, goes back to this ward guardianship relationship. And this is very difficult for a lot of people to understand because they're like, why isn't there a Black children in Child Welfare Act? Why isn't there a Mexican Children Welfare Act? And the big issue is because there is this unique political relationship between tribes and the federal government that makes it the responsibility of the federal government to intervene and make sure that they are protecting tribal communities, make sure that they are looking at the best interests of tribes. And given these statistics, Congress needed to act. So we talked a little bit, or Geneva shared a little bit about how ICWA's remedial statute, and ICWA really took all of these issues that they were finding with unwarranted removal. And these unwarranted removals were some things just as basic as a house was dirty, not understanding how a child rearing practices of a specific tribe were. And then in looking at some of the congressional reports and testimony, there was one case where the state of California didn't want the kid returning to the South Dakota reservation because they didn't think it was appropriate. And they said that the reservation is so poor, the reservation is so bad. In this foster family here in California, this kid will get a better life. So a lot of this misunderstanding about how to protect Indian children, or what was the Indian child's best interest. And like that video really highlighted, these removals were preventing Native children from no longer being connected to their communities, connected to who they were. The other thing that Congress found prior to passing ICWA was that state courts often fail to recognize this essential tribal relationships of Native people, and why relationships were very important in protecting and keeping tribal communities together. Understanding the cultural and social standards prevailing in Native families and communities. So it wasn't just entities like child welfare coming in and removing these children. It was also state courts who had no understanding of what was in the best interest of the child. And it's really interesting if you want to do a more deep dive in dependency. Generally, there's really nothing for child welfare at this time. Most of it is really focused on aid to dependent mothers, or mothers who are single and unwed and were trying to raise their children. But there wasn't really anything related to children who for abuse and neglect or being removed for these issues. And so ICWA was really on the front line for kind of how to address best practices and moving forward, what to do to keep families together, to prevent the breakup of families. And it's why today so many child welfare organizations look to the Indian Child Welfare Act as the gold standard for child welfare practices. So one of the key components of the Indian Child Welfare Act is preventing the breakup of the Indian family. And one of the key requirements to prevent the breakup of the Indian family is ensuring that active efforts have been provided. And active efforts must be provided from the moment an Indian family touches state contact, so that could be at referral, that could be at an investigation phase. And oftentimes for probation departments in your work, it might be the immediate point where you get information for, hey, we have a juvenile delinquency matter. And really the focus is making sure that active efforts are provided to prevent the breakup of the Indian family. So social workers, and a lot of this is focused on social work for child welfare and dependency matters. But there is a lot of analog in probation. And so we'll talk about that a little bit more, but investigating social workers must engage in active efforts to prevent the removal of the child, or while investigating whether or not the child is a member of a tribe, is eligible for membership in the tribe, or whether the biological parent of the child is or is not a member of a tribe. So there's a lot of requirements in trying to make sure that preventing the breakup of the Indian family happens. And the purpose of ICWA, again, is to really focus on making sure that tribes are involved. making sure that tribes are aware of all of these cases. So what Congress also found in these removals is that oftentimes tribal leaders, tribal social services departments, tribes generally just didn't even know what was happening to their kids. They were not able to maintain any records. And because of that removal, because of these children being placed off in different places, a lot of our enrollment data dropped. A lot of tribes were not able to say, hey, this is a member of a tribe. This is somebody who is here. This is who is a descendant of this other person, and so forth. There was no way for tribes to keep good data on who were members of tribes and who were not. And Congress and also the United States government, in a case called Santa Clara v. Martinez, said that tribal communities tribes are very much responsible and have the authority for determining membership for their tribes and determining what criteria is essential for making sure that a child or a person is deemed a member. So again, going back to the idea of membership, it's really hard because folks try to understand this and tribes membership isn't related to race, or it's not a racial category. It's connected to a political status. And again, it goes back to that unique federal relationship the federal government has with tribal communities and tribes generally. As sovereign nations, we're deemed as our own entities, and we are able to, again, control who is a member, determine who is a member and who isn't. And that is completely different than what I identify as racially. And it does cause a lot of confusion for folks because they're like, well, you're also racial, but you're also a political status. Like, I don't get it. For the purposes of Indian Child Welfare Act, the way that we are, Indian children are involved, the way Congress, and the reason why Congress has this unique responsibility is again tied to the fact that there is this unique political relationship. So Congress found that the purpose of the Indian Child Welfare Act was to protect the best interests of Indian children and Indian tribes by recognizing that no resource is more vital to the continued existence and integrity of Indian tribes than their children. So that's the most important part. That's what Congress found. That's what Congress has said. If you look at California statute, this language is also found in California statutes as well. It is really important, and it's why California has deemed it there to be this necessary connection to make sure that Indian children are being protected across the board. There is this, tribes cannot continue to exist. Tribes have faced extinction so many different times, and Geneva shared all of the different ways we have almost gone extinct. And ICWA is one of those ways, that remedial statute that exists to try to prevent this disintegration, this elimination of tribal communities. And when tribes don't have our children, we don't have anything. And I don't know if you guys have been listening in the news or not, but there's a big concern for China, for the United States, about how many kids are being born. China just raised their number of children to be that can be born by every family to 3, huge number and huge increase. And part of it is because everybody knows that without our children, our communities don't continue on. And it's the same thing for Indian children. It's the same thing for Indian tribes. Without our Indian children, without protecting them and without having them around, we essentially don't exist. We don't have anything to carry on our legacy, our culture, our language, or everything else. Okay, so really briefly, tribal sovereignty is very important because tribal sovereignty is one of the key components of ICWA. And it basically just means that tribes have the ability to self-govern. They have the ability to determine rights, and inherent in tribal sovereignty is this idea that there are inherent rights of tribes to self-govern. So a lot of words, they kind of mean the same thing and they all relate the same way, but essentially tribal sovereignty means that tribes have the ability to determine what they do. And it all goes back to like their membership. They're able to determine their membership. They're able to govern themselves. They're able to set their own laws and create their own requirements. And tribes that continue to be entitled to all reserve rights. Tribal sovereignty also supports the idea that if a tribe was given rights through treaty or legislation, those rights are reserved. And some of those reserved rights can be like fishing rights, hunting rights, land rights, so on and so forth. But the big idea is that tribal sovereignty is that tribes are able to self-govern. They're their own political entity, and they don't have to answer to anybody else. We have this other new law called, or this other law, not new, passed in the 60s, called Public Law 280. And Public Law 280 is easier to understand in the context of what doesn't happen with Public Law 280. So outside of Public Law 280 states, which California is, the federal government is responsible for prosecuting cases that include criminal cases involving major crimes. So like kidnapping, rape, murder, assault, so forth. And in those cases, tribes can also do that. Tribes have the ability to create their own criminal courts and criminal justice systems and criminal codes to prosecute those crimes. However, in public law and in the state, in non-public law 280 states, so like for Arizona, for example, the state would not have any involvement. The only time the state would be involved in a crime that occurs on a reservation is if there were two non-natives committing a crime together, because then no, the tribe would not be able to. So for example, on the Navajo reservation, say there is a gunfight and somebody shoots and kills somebody else. Tribes would not be able to prosecute it. Tribes may be the first responders, but then they would call the state and say, hey, crime was committed by two non-natives, come check it out, come investigate, come handle it. And the state, even though the crime was committed on tribal lands, would be responsible for doing all of that. In Public Law 280, it's completely different. Instead of the feds having responsibility to look at all of that, the feds said, nope, we're giving that all to the state. The state is handling all of those issues. And so through Public Law 280, there's concurrent criminal and some limited state civil jurisdiction in Indian country. And so what that ends up meaning is that the state has the authority to prosecute crimes involving Indians that are occurring in Indian country in state courts, which wouldn't happen in a non-public law 280 state. Additionally, they have the authority to handle civil matters, some civil matters. And one of the areas that there's this concurrent civil matter area is in dependency cases. So through Public Law 280, there's this concurrent jurisdiction that exists, especially relating to Indian child welfare. Okay, so what are some of the factors that might affect and impact this tribal state relationship? So obviously Public Law 280 is one of those, it's one of those factors that really impacts who is responding to what and kind of where. And there's a lot of challenges with trying to figure out when tribes are very rurally located. A lot of times tribes have challenges with trying to get local state entities, whether it be the county, whether it be the city, whether it be state highway patrol, to kind of like help out and figure out how to handle these criminal jurisdiction issues. The other thing is that even though Public Law 280 exists, there's still a federal trust responsibility that exists between tribes and federal government. So even though Public Law 280 came and asserted this new jurisdiction regime, tribes ultimately still have to work with the federal government because they are still the guardian and tribes are still the ward. Other things that happen are various federal Indian policies that affect. These policies may affect how Indian Child Welfare Act is occurring, or like what Indian Child Welfare Act factors are existing, and you have the laws from the federal government and then you have the state, and kind of what does that look like? And then again, we talked a little bit about Public Law 280 in the prior slide. So these are some of the kind of areas where tribal state relationships can be hampered, or they can be slowed down in building positive relationships. Because tribes have to work with so many different entities, it's hard to like balance who to respond to or who is responsible for what. And then with Public Law 280, this new overlay of concurrent criminal and civil jurisdiction, it does create a lot of confusion as to what do we do? Who is the agency that we need to be reporting to? Okay, so we have this short video. It's really good because it helps explain tribal sovereignty generally. It helps explain all of the unique federal responsive or the federal policies that exist, and it's really short and it does a quick job of summarizing it. We try to throw in different pieces so that folks can understand the various levels of federal Indian policy and how they affect Indian children and Indian tribes generally. And this is just one of the other ways that we're hoping you can absorb this idea. So go ahead, Geneva. Thanks.
Did you know that Native American tribes are basically their own nations? In fact, they've been that way since well before the start of American history. It's called tribal sovereignty, but protecting it hasn't been an easy task. Let us explain. There are currently 573 federally recognized Native tribes in the U.S., and every one of them has the right to govern themselves and their lands. Before the Constitution existed, before the U.S. itself existed, American colonizers struck tons of treaties with the indigenous tribes and thereby recognized tribes as independent nations. And when the Constitution was enacted in 1788, it too recognized their sovereignty, not just from the federal government, but also states and foreign nations. But soon after, their sovereignty was put at risk. In the 1800s, a series of Supreme Court cases ruled that indigenous tribes were domestic dependent nations, meaning they had lost certain rights of a self-governing nation like raising an army because they were seen as inferior people in the eyes of the United States Supreme Court. But there were more challenges to come. First, the federal government tried relocating all tribal nations by exchanging their homelands with less valuable lands. Then, when the tribes failed to assimilate, the United States broke up reservations by a process called allotment. Allotment gave each tribal member a piece of land with the hopes that it would become economically productive. But instead, it resulted in the loss of millions of acres of tribal property. In the 1950s, Congress passed legislation that aimed to assimilate Native Americans into mainstream Western society. More than 100 tribes were terminated and had their recognition and sovereignty revoked. The result was a flurry of economic and social issues for the Native community, issues that persisted even after the policy ended. Since then, Native groups have regained some of their rights, and the government has taken a more supportive approach to tribal sovereignty. Today, tribal nations work to rehabilitate endangered species, restore their traditional languages, and address the epidemic of murdered and missing Indigenous women in Indian country. But the debate still isn't over, because the right of Indian nations to self-govern is often being redefined and challenged, despite the fact that its history predates even the birth of our colonized nation.
So again, we just wanted to highlight that there is a lot of history that really comes into play and understanding why the federal government is involved in protecting and making sure that Indian children are protected. It relates to a lot of what was previously discussed in that video. So some other factors that we kind of just wanted to touch on is that there is a disproportionality of Indian children in child welfare system. American Indian and Native Alaskan children are in foster care at double the rate of non-minority children. There is a discrepancy of available funding for child welfare activities. And going back to Public Law 280, for a long time in California, there are 110 tribes in California, federally recognized tribes. There are some, I think it was like 90 other tribes that are petitioning for federal recognition in California. And then there's a host of tribes that are recognized only by the state as well. But the federal government's government to government responsibility, trust responsibility only extends to federally recognized tribes. And so for 110 tribes, whenever they tried to reach out to the federal government for grants and funding and so forth, the federal government was like, we don't have a responsibility because Public Law 280 exists in California. And that funding, your funding stream must come from California directly. And so until about like 2016, a lot of tribes didn't have this ability to get funding to build child welfare codes, to build their own tribal infrastructure. Tribes don't own their land. And oftentimes people are thinking like, well, tribes have money, they have casinos, they have gaming, they can afford this, but not every tribe does. And because of that, there is no economic base for tribes to tap into to build their own infrastructure. And it causes a lot of stress and a lot of challenges for implementing this tribal sovereignty, this ability to self-govern, because without funding, without a tax base, like your county, your city, in the state of California, we're not able to assess taxes on things to bring in revenue. And because of that, we're not able to build a lot of different programs to help with these issues. Other kind of areas that really affect it are just the differences in values and child welfare values and practices, misunderstandings about what constitutes family, community, culture, and permanency. And then lastly, in court cases or just in cases generally, anytime there is a disagreement between tribes and states, there is this idea that there is a winner or loser, and we're going to take it to court so that the court can hash out and determine who the winner and loser is. And oftentimes these create big tears in the relationships that could exist, that could have positive tribal state relationships. These are things that kind of get in the way and make it so that it is harder to have positive relationships. So it's really important for tribes and state departments and county departments to really work on teaming, because as the statistics before showed us, 25% to 35% of Indian children were being removed from their tribal communities. And that's still the same rates of removal. In California, there are 4 counties with children with, even though Native Americans make up less than 10% of the population in 4 different counties, we still represent there's still this disproportionate rate of number of kids in care, Native American kids in care. In Humboldt County, the number of children in care that are Native American are 38%. In Inyo County, it's 36%. In Del Norte, it's 29%. And in Lake County, it's 15%. So we're still seeing all of these challenges and misunderstandings related to child rearing and child practices that show us that ICWA is still needed. We still need ICWA to kind of be involved and make sure that county systems and state systems are really looking at what is culturally appropriate and what is relevant. And then we just have a couple more statistics relating to Native American and Alaska Native youth. And we really wanted to highlight this because this came from a 2013 report that was prepared by the Indian Law Commission. And it just highlights how graduation rates are low, 17% lower than the national average for Native American Alaska Native youth. Their Alaska Native and American Indian youth are twice as likely to die as their non-peers before the age of 24, 2.5 times at greater risk of experiencing trauma than compared with non-Native peers. They have the highest per capita rate of violent victimizations. Twice as likely to be placed in foster care, and Indian juveniles experience post-traumatic stress disorder at a rate of 22%, triple the rate of the general population. So these are high numbers for really addressing and looking at what is happening with our American Indian Alaska Native youth. And now we're going to get into the nitty-gritty of ICWA. ICWA applies to what? I think that's the name of the game, and that's what people are really trying to figure out. Child custody proceedings involving Indian children. This includes voluntary and involuntary proceedings that may result in an Indian child's adoptive placement. Any action removing an Indian child from the parent or Indian custodian for temporary placement in a foster home, institution, guardianship, or conservatorship, where the parent or Indian custodian cannot have the child returned upon demand and the parental rights have been not have been terminated. So that is what the code says. That is what the federal ICWA says. Let's move on and go into a little bit more about the key provisions. So we have a broad overview of when ICWA applies. Now we have these key provisions of ICWA, and the key provisions are, again, ICWA was meant to be a remedial statute. It was meant to address some past harms and make sure that these past harms were not didn't occur again. So we have noticing provisions, we have inquiry provisions, we have requirements for active efforts, intervention, tribal jurisdiction and transfers, expert witness and evidentiary burdens, and placement preferences. Again, ICWA, since it's remedial, and in the law, it also says these are federal minimum standards. So if you want to go above and beyond, great. But always remember that this is the floor. It is not the ceiling for any of the work that is related to Indian child welfare. So the definitions of Indian child welfare are really important in understanding how to and when ICWA applies. An Indian child is an unmarried minor that is either a member or is eligible for membership in an Indian tribe. And the child is a biological child of a member. ICWA also applies for non-minor dependents unless the youth opts out. So the youth can make the determination on how much or what provisions of ICWA apply. And remember, as we stated above, as part of the general principles of tribal sovereignty, membership can only be determined by tribes. This isn't something the court does. This isn't something a social worker does. This isn't something that probation officers do. This isn't something the attorney does. This is something that can only be determined by the tribe. And then the definition of an Indian parent is any biological parent or parents of an Indian child or any Indian person who has lawfully adopted an Indian child, including adoptions under tribal law or custom. The biological parent does not have to be Indian to have the protections of the Act. So if we have one Indian parent and a non-Indian parent, the non-Indian parent will still get the protections of ICWA. ICWA is the provisions of ICWA are triggered by the fact that there is an Indian child and that the child that this individual, this child meets this definition above of what an Indian child is.
Really quickly, Mica, before we advance, I just want to point out, because I certainly have been using language interchangeably, talking about Indian child, Indian family, Indian parent, Native American, Native, tribal. I just want to emphasize that Indian is this legal definition, right? So as you can see here, these are legal definitions. As any of you know who are or interface with Native peoples in a contemporary context, many of us don't use that terminology to identify ourselves today. So it is a legal definition, and there are a variety of different ways that Indigenous peoples, tribal peoples, identify themselves, whether it be their specific tribe. So the word Indian is a little outdated in that way, but it's very important because it is in fact a legal definition.
Thank you, Geneva. Okay, so we got some time. We got about 20 minutes left to zoom through the rest of these slides. So get ready to zoom through. Okay, so California has this ability or this applicability called the Spirit of ICWA, and it was passed in SB 678 in 2006, and it basically applies ICWA to unrecognized tribes. So these are tribes that are not federally recognized, and the court has the discretion of allowing non-federally recognized tribes in California to be present and advise the court in regards to placement and services for their tribal children. And so the Spirit of ICWA also extends this the provisions of ICWA to delinquency proceedings as well. Okay, so again, we have more definitions. An Indian tribe, like we said before, is really focused on this federally recognized tribe. So a tribe must be recognized by Congress or the Secretary of the Interior through a list that they maintain and designate as being an Indian tribe. And again, tribal membership is solely at the discretion of the tribe. The tribe has the exclusive rights to determine the requirements for membership, and they are the ones who will make the determination of whether or not a child is a member of their tribe. Okay, so going into inquiry, when does inquiry come into play? So for court, county welfare departments, and probation departments, there is an affirmative and continuing duty to inquire whether a child who is the subject of a petition under section 600, 601, 602, or 300, if they are an Indian child. And so the responsibility or the duty to inquire begins at initial contact, including but not limited to asking the reporting party of child abuse or neglect whether he or she has any information that the child may be an Indian child. So inquiry, the purposes of inquiry in the Indian Child Welfare Act is to make sure that tribes, make sure that a child has been identified, and make sure that the determination that there is an Indian child is involved. And then through the inquiry process, you are able to identify or inform the tribe and get the tribe involved on the cases. Because like we said before, oftentimes tribes were not being alerted to cases involving their Indian children. So inquiry really came about to make sure that this questioning is done and this questioning occurs. And it's really a unique history with asking questions about whether or not a child is an Indian child. There are sometimes some people may not want to disclose that they are Native American just because of the past trauma and the past harms that have been inflicted upon them. Some of them think that it might be very disadvantageous for them to not identify as Native American. But we also encourage folks that when talking to folks about their Indian heritage and Indian ancestry, to really highlight that there are benefits that come from the Indian Child Welfare Act's application to a case. And really just kind of like highlighting that, you know, your tribe may be involved, your tribe may be able to help out and provide services and supports that the county might not be able to, our probation department might not be able to. So really just kind of like thinking that through, and then really ensuring that it's not something that's going to be used as a negative thing against folks who are identifying that they are Native American. Okay, informal notice. So through California recently passed AB 3176 in 2018, and this included this requirement of informal notice. And through informal notice, there is a duty to call and interface with tribal representatives. And unlike formal notice, where you send out like all of the information related to the child's like relatives, great grandparents, and so forth, informal notice can be very informal, and it can take the form of picking up the phone, making a call, sending a fax, sending an email. Really, the point of informal notice is to help bring the tribe in early, increase the collaboration, pull in supports. Sometimes the tribal child or the Indian child may be getting supports from TANF or a tribal health department or an education department or other services that are designed for Indian children specifically. And then in the cases of preparing for removal or placement in a different outside of the parent's home, really focusing on those family finding efforts. A formal notice, on the other hand, is the more specific form, making sure that you are identifying the agency or the petitioner. There must be notice to the parents, the legal guardians, the Indian custodian, the tribe, whether there's one or multiple tribes that have been listed, and the BIA of all pending petitions and any hearings. Notice must continue to be provided until it is determined that ICWA doesn't apply. Initial notice should be sent in the form of the ICWA 030 to the tribal chair or the designated agent. And the designated agent for service, or who the tribal chair is, can be found on the BIA's website, linked here. And they have a form that they release, or a document that they release every year, that lists all of the tribes and the designated agents for formal notice. Okay, so intervention. One of the key things and one of the remedial aspects of ICWA was to ensure that tribes are able to participate in cases involving their Indian children. So tribes, as well as Indian custodians, have the right to appear and right to intervene at any point in a proceeding, and they may appear by counsel or by other representative. Intervention also makes a tribe a full party to the case, and they can have access to documents, reports, anything that's been filed with the court. And some tribes may choose not to intervene because they don't have resources. And this is oftentimes one of the bigger areas where we get a lot of questions. We have a child who is an Indian child, but I can't get the tribe to appear at the court hearings. What do I do? Sometimes it's just a matter of the tribe not having the resources to participate in every single case. So in that instance, they may decide to monitor a case and not intervene. Regardless of whether or not a tribe intervenes, the key turning point is whether or not there is a case involving an Indian child. And if there is an Indian child involved, then ICWA applies. Okay, so we talked a little bit about active efforts. Active efforts, again, must be provided to prevent the breakup of an Indian family. And this is through the provision of remedial services and rehabilitative programs. The court, especially in dependency cases, must make a finding that there is clear and convincing evidence that active efforts were provided. This is really, really important before you get to a termination of parental rights hearing, and making sure that there is a finding that active efforts have been provided to the parents to prevent prior to termination of parental rights. And then California law requires the agency to make active efforts to follow ICWA placement preferences. So active efforts is more than just providing services to the parents. It's also about making sure that all components of ICWA are being applied and that you are meeting this heightened and elevated standard of active efforts. There has been case law in the past that said active efforts is the same as reasonable efforts, but with the passage of AB 3176, California law codified and stated and elevated that active efforts is not the same. It is a heightened standard. It is active, timely, thorough, and affirmative. So we don't have a definition for reasonable efforts in the Welfare and Institutions Code, but we do have a definition for active efforts. And it really shows that the legislature has this intent of ensuring that active efforts are provided and that it is a different standard than reasonable efforts. Okay, so again, some of the requirements of reasonable efforts, it's not passive, it has to be more than reasonable services. The efforts are to be culturally appropriate, and they must specifically take into account the prevailing social and cultural conditions of the child's tribes, and efforts that are made to keep the child's extended family, the tribe, Indian social services, and Indian caregivers available to the Indian child as well. Okay, so then let's jump into ICWA placement preferences. So ICWA has two different sets of ICWA placement preferences. Again, the focus is making sure that Indian children are not placed outside in non-Indian foster homes and non-Indian adoptive homes. So for foster care placement, there is a requirement that the child would be placed in one of these in descending order. a member of the extended family, foster home approved by the tribe, an Indian foster home, and an institution approved by the tribe or operated by an Indian organization. Some tribes may have different placement preferences. So if you have a case and you're trying to determine where a kiddo is going to go, you might need to check in with the tribe to make sure that they don't have a specific order for placement preferences as well. And then we have this other area for adoptive placements. So if you have a case where you're going towards adoption, that's pretty rare, but in that instance that you do, you must look at the different types of placement preferences for the placement preferences that are set for adoptive placements. That includes a member of the extended family, other members of the child's tribe, and other Indian families. So the preferences are very different from foster care to adoptive placement. And again, active efforts must be provided in ensuring that placement preferences the ICWA placement preferences are followed. This requires consulting with the tribe and using any available tribal social services when making placement of an Indian child. And the tribe may establish a different order of placement plus preference by resolution, so be sure to check with them. And if a child is not placed in accordance with the ICWA placement preferences, the petitioning party must show that there is good cause to deviate. And bonding with a non-ICWA preferred placement preference does not equal good cause. So you must show through clear and convincing evidence that there has been a diligent search to find a suitable home that meets the ICWA placement preferences. And then in regards to placement preferences, there is also the standard that's found in Welfare and Institutions Code section 16519.5. And it states that in the case of an Indian child for whom the child's tribe is not exercising its right to approve a home, the county shall apply the prevailing social and cultural standards of the Indian child's community and to the resource of family approval for that child. So this was recently added. I believe this was passed in 2018 in AB 686. And it really just made sure, because when the resource family approval program was passed, it didn't take into consideration ICWA and all of the requirements of ICWA. And so this was a new standard that was added in after the passage of the resource family approval. So now we need to make sure that any home, foster home that a child goes to that is a resource family home also applies the prevailing social and cultural standards of the Indian child's community. Okay, and so the Indian Child Welfare Act authorizes tribes to approve homes for placement for their own children. And so what does that mean? Let's look into that a little more. So we have two terms that kind of exist in this realm. It's called tribally approved homes and tribally specified homes. So tribally approved homes are homes that have been licensed or approved by an Indian child's tribe for foster care and adoptive placements. And the licensing is all conducted by the tribe. And California has this specific language codified. If you look in the federal ICWA, you will not find tribally approved homes. You will only find home approved or foster home approved by a tribe. And so in this case, the tribe will conduct the assessments. They'll do everything like resource family. Some tribes have the ability to conduct background checks, but the vast majority of tribes in California will rely on the county to conduct the background checks for home approval. The other term that we wanted to make sure folks knew about is tribally specified. And this is really more important for like CMS, CWS, like databases and so forth. It's more specifically just the home that the tribe has designated as preferred option. Here, the tribe doesn't engage in the approval process, but they may be kind of along the way looking at the home, participating in the assessment process, but they're not the ones who are going to be the licensing agency. Okay, so we just wanted to highlight some emergency placement best active efforts best practice. So again, At the very beginning of the case, there is a duty to inquire and determine whether or not an Indian child is involved. And so the purpose of that is to identify Indian children early on in the case, so that if you need to find an emergency placement, you can contact the tribe to identify potential ICWA compliant emergency placement options. Additionally, to determine who will contact whom in the search of an emergency placement. So reaching out to the tribe will very much help when trying to find out, or getting your team together to find the best placement for an Indian child. And then ensuring that both parties are aware, the county and the tribe are aware of who's going to be running background checks, who's going to be doing the home approval process, because in some instance, the tribe may intervene, or the tribe may say, we want to do the tribally approved home route, and just kind of talking through what that would look like in a specific case. And then county and tribes collaborating by going out to the home assessment, or to go out and do the assessment together. Obviously it's very helpful for ensuring that you are determining the best needs and assessing whether or not a placement is appropriate for a specific child. And then one of the other requirements for ICWA is a qualified expert witness. We won't spend too much time on this just because oftentimes it's not really relevant to probation, but we wanted to make sure you guys were aware of it, heard the term, made sure it was something that you saw and weren't like, oh, I don't know what that is, if it ever came up. So qualified expert witness is required when a child is entering foster care. So if you have those dual cases where it's a 600 and a 300 petition, if there is a case involving an Indian child, a qualified expert witness will be needed to make the foster care placement order. And then if you have a case where it is going towards termination of parental rights, you will need a qualified expert witness. And here is the requirements for an expert witness in descending order. So some best practices for the QEW, the qualified expert witness, is, first of all, talking to the tribe and making sure that you have communication with the tribe about who is going to be the best person to serve as the qualified expert witness, and really working with them on identifying who is the best person. And if the tribe does not agree with the selection, the tribe may submit a letter to the court listing their preferred person, or to a child welfare agency requesting their person, or the tribe may also hire their own QEW as an alternative to the qualified expert witness selected by the county. And then permanency. We also just wanted to throw out some ideas. The idea of permanency, especially in ICWA, is very much the same, but one of the highlights of achieving permanency in ICWA cases is it's more than just the legal permanency of establishing a home for the child. It's making sure that there is stability in the home, making sure that there's relational permanence, and connecting the child to all of the cultural resources that the child needs. And ensuring that the child has connections to any siblings or other relations that are important to the child. And then ensuring cultural connectedness. So if you want to learn more about permanency, we have a link here from the University of Iowa's School of Social Work. And then the specific ICWA provisions that apply in California juvenile delinquency cases. So there's a case that came out in 2012 called In Re WB, which really limited the amount of application of ICWA to juvenile delinquency cases. But again, there is this affirmative duty that has been codified in AB 3176 that says probation officers have a duty to conduct inquiry. This starts at initial contact. And then if they are cases that are dual cases, or if the child is at risk of entering foster care, then these other provisions, if these other provisions apply, then ICWA also applies. If the petition only alleges a status offense, so if it's a crime that is going to be charged as an adult. ICWA generally doesn't apply in those cases. If the court has set a hearing to terminate parental rights, no criminal conduct is required, or, you know, the criminal conduct is not kind of one of those things that precludes it. Then ICWA should apply, it will apply, or the court has placed the child in foster care or an adoptive placement due to abuse or neglect. So you might have a child who has a status offense, but then there's also this other layer of abuse and neglect that comes up, and then the child is placed in adopt or foster care placement. In those instances, those provisions of ICWA that we talked about before apply in the case.
And Mica, I just wanted to say we're actually a couple, the session ends in about 3 minutes. So I don't know if you want to quickly go over some of the slides, highlight some main points. We also had a question that came in about is an expert witness needed for probation only placement? So I just want to flag that for you. We have only a couple minutes left.
So really quickly, expert witness is really going, if it's a probation only placement and you are going towards termination of parental rights, then you will definitely need a QEW. Other instances, it'll be a wobbler, kind of going back to that last slide of like the other requirements. You'll kind of have to go through that analysis to make sure that it's not one of those cases that involve ICWA and or that doesn't implicate ICWA for probation purposes. So it's really hard for probation officers, you know, because it's one of those case by case basis. You have to go through and kind of conduct an analysis. And there's no clear and easy way to conduct analysis on probation departments.
Excellent, thank you. So in conclusion and in wrapping up, just, you know, think about, how do you show up in community? How do you engage with the communities that you serve, not only in times of challenge and stress, but in times of celebration and wellness? How do you establish yourself as a helper, do what you say will you do, and collaborate with other Native organizations and service providers? So in doing so, we have a couple suggested activities ranging from research and participation in tribally sponsored community events with colleagues, friends, family, get to know the communities that you work with, see how folks come together, you know, get some, you know, cultural knowledge, you know, break bread, share food with people, however you're able to do that. So again, you can experience peoples and communities in a more balanced way. And then finally, how do you get to know your tribal resources in your county or region? Do a little bit of research, get to know those agencies, get to know what services they provide, and identify ways that you can build or strengthen collaboration opportunities and engage in reciprocal relationships that ultimately, you know, achieve better outcomes for children and families that we serve. Thank you all for joining us today. That does bring us to the end of our time. We appreciate your attention. I know it's a tough format to learn in, 2-hour virtual, rapid, you know, instruction. But we thank you all for your commitment to the ongoing compliance and spirit of the Indian Child Welfare Act. Here is our contact information, as well as some other resources to get even more information about ICWA compliance and associated ICWA compliance issues that will be available in your handouts. And then feel free to follow California Tribal Families Coalition on Instagram and other venues to see the most up-to-date legislative and policy updates, as well as other training opportunities in the future. Thank you so much.
Thank you, Geneva and Mica. Really appreciate it. This was very informative. I've actually learned a lot during this, watching this presentation, and I'm sure there's much more to learn, and hopefully we can partner with you again where you can present and share this awareness. So really appreciate that. And for those that are interested, there is going to be a ICWA statewide conference that the California Tribal Coalition is going to be hosting, and that's on June 24th and 25th. And I've actually sent out information to the CCR point of contacts. However, if you want to just do a Google search and just say ICWA statewide conference, it will actually pull up. Just remember, it'll fall under California Tribal Families Coalition. So you should be able to easily find that. And then I just want to thank our attendees for participating today. I hope you found it helpful. If any questions come your way, please feel free to answer, send out an email. over to Geneva, Mica, or feel free to reach out to us and we can most definitely connect you. With that being said, thank you, everyone. I just want to say that don't forget to join us tomorrow at our 9 a.m. session. It's on wellness, and we have a lot of great sessions coming up tomorrow. It's our last day of the conference, so hope to see you soon.